Good afternoon. Welcome. I'm Joe Peiffer, the founder of Ag and Business Legal Strategies, an uncommon law firm located in Cedar Rapids, Iowa. I grew up on a hog and dairy farm in Delaware County. I studied dairy science at Iowa State University, and for most of my career, I represented farmers and other business people. Most of the time, when I work for clients, they're debtors, having trouble with their creditors. But on occasion, I get the privilege to represent farmers who are creditors, like farmers and corn producers in the Verasun ethanol bankruptcy filed in Delaware in 2008. Verasun was the nation's largest ethanol producer. It had over 20 plants, and all the cases were filed in the state of Delaware. About 2 years after the case was filed, the liquidating trust in Verasun sought to have all of the farmers that got paid for their corn on time give back the money, claiming they were preferences. Like in the Verasun bankruptcy of a decade ago, in Dean Foods, it filed for bankruptcy, this time in Houston, Texas, and it's seeking to recover money paid to milk producers, suppliers in the 90 days leading up to the bankruptcy. Dean Foods filed its bankruptcy on November 12th, 2019. So the attorneys in the Dean Foods bankruptcy appear to have not adequately considered the defenses to the milk suppliers. Suppliers should not just roll over and play these demands without consulting an experienced bankruptcy attorney to analyze their possible defenses and determine the extent of their liability. The mass mailing of defenses or of the preference demand letters reminds me of spammers or junk mail people. They send out a lot of demands, and if they get some people to bite and pay, even though they shouldn't pay, they've got some extra money. Don't be one of those people that rolls when you don't have to. I prepared a short presentation, and after that, I'll take questions. If you think of questions during the presentation, type them in the chat box so you don't have to remember them, or you can wait until the end to raise your hand when we can unmute you and hear your question orally. Thank you again for attending. I'm going to shut off my screen so we can all, my camera, so we can all focus on focus on the presentation about the Dean Foods preferences. And an outline of what we're going to be going through. First, we're going to cover a little bit about the Dean Foods bankruptcy and the actions of the Farm Bureau. We're going to talk about bankruptcy basics, what's going on, and how bankruptcy works. We'll discuss what a preference is. We'll discuss whether you should pay the demand, and we'll have a call to action. Farm Bureau has stepped up in a big way. They sent a lengthy letter, 4-page letter to ASK LLP, the law firm from Minnesota that has sent out the demands for creditors of Dean Foods to repay the alleged preferences. Farm Bureau has insisted that the demand letters sent to the milk producers be withdrawn, that any payments that have been made pursuant to those letters from milk producers be refunded because the producers have valid defenses to the preference. That is the eventual outcome that occurred in the Verasun ethanol bankruptcy 10 years ago. A group of us put together the Verasun Preference Defense Group. When we put that group together, there was a number of lawyers from around the country, and we responded to the preference demand letters from the law firms in New York and Delaware that were sent out in Verasun, with a strong defense pointing out that the farmers had an excellent defense and that the Verasun bankruptcy should not get any money back. My recollection is that no farmer was sued by the Verasun folks after those letters went out. We're very hopeful that the Farm Bureau letter gets the Dean Foods people to back off. If not, then it'll be necessary to respond to those demands so that you can protect yourselves. Doing nothing is not the idea. It's best that you be prepared and move forward. If you're interested, and for a link to the Farm Bureau letter, send an email to deanfoods@ablsonline.com, or you can call 319-363-1641. Again, if you want to see the Farm Bureau letter, send an email to deanfoods@abls, as in Sam, online.com, or call 319-363-1641. Now it's just some bankruptcy basics. In bankruptcy, there are two general goals. There's generally not nearly enough money to go around, so everybody's not going to get paid in full. So the goals of the bankruptcy are to first collect the assets to distribute to creditors. And the second goal is to treat similarly situated creditors the same. For an example, in bankruptcies, the assets are liquidated so the proceeds can be split up. When the distribution occurs, if two creditors have similar claims, they should be paid in a similar fashion on a pro rata basis, instead of giving more to one than the other. An easy example is this. Assume in a bankruptcy, there are creditors holding claims of $100,000. And these are unsecured claims, no collateral, just the debtor owes them, total of $100,000. The first creditor in this group, we'll call the unsecured creditors, is owed $50,000. The second creditor is owed $30,000. And the third one is owed $10,000. And the fourth one is owed $10,000. When it comes time to distribute the assets, the trustee has been fortunate and he's picked up $50,000 to distribute to the creditors who are owed $100,000. In that example, the creditor that is owed $50,000 will get one half, or the creditor owed $50,000 will get one half of the total brought in by the trustee or the bankruptcy. Half of 50 is 25,000. That's 50 cents on the dollar. The creditor that was owed $30,000 will get half of its amount, or $15,000, and each of the other creditors that were owed $10,000 each would each get $5,000. So that's treating similarly situated creditors the same. In a preference action, what is it? A preference action is an avoidance action. It's designed to help achieve those two bankruptcy goals. By avoidance, that means that we back away and we undo something that has occurred. A preference action is an action to collect assets. In the bankruptcy code, the money that can be received from preferences or other avoidance actions are viewed as assets by the debtor or a trustee. It's just as if the recipients were holding the money for the debtor. However, preference actions do more to prevent unfair treatment. Imagine if right before filing a bankruptcy, a debtor paid some creditors in full and left others out in the cold. That's not very fair, and the preference avoidance actions can help minimize or mitigate that. Back in the example I just gave, where we had 4 creditors, one owed $50,000, one owed $30,000, and 2 owed $10,000. If the debtor chose to pay his best friend that was owed $30,000 in full, that wouldn't seem fair to the other 3 creditors. One of them got paid 100 cents on the dollar, and the others only got paid later. They can't get paid 100 cents on the dollar because that money was all paid to the $30,000 creditor. While in theory, having preferences and getting money back to share may seem good, in the Verison and now the Dean Foods bankruptcies, the theory demonstrates what may be sound in theory may not be fair in practice. And for the practical reason why this is happening, it's all about the money. Dean Foods creditors have a strong voice in the bankruptcy. They had Dean Foods hire ASK LLP, a law firm on a commission basis, to prosecute these preference actions and try to get more money back for these creditors. Dean Foods is out of business. Its assets have been purchased by Dairy Farmers of America, DFA. ASK LLP doesn't work for people like milk farmers or other suppliers or other creditors, so they don't have to worry about maintaining a reputation in the community. It's all about an effort to get the most money with the least effort. So what's a preference? Let's define it more clearly. What is a preference? Generally speaking, a preference is a transfer within 90 days, the 90 days prior to bankruptcy. In the case of Dean Foods, the bankruptcy was filed on November 12, 2019. 90 days before that would have been August 14th, 2019. So it's a transfer, or generally a payment, made within 90 days before the bankruptcy that will be used to pay a pre-existing unsecured debt. For example, when a farmer sends milk to the dairy, it has an unsecured claim against the dairy to pay them for the milk. The debt is pre-existing in this instance because it's there on the date that the farmer is paid. So if a farmer sends milk from the 1st to the 15th of the month to the dairy, and then at the end of the month gets paid the advance payment for the first half of the month, that advance payment is applied against the pre-petition, pre-existing debt, because by the end of the month, the dairy owes them not only for the milk delivered from the 1st to the 15th, but also the milk delivered from the 15th on. So that would be a pre-existing debt. And in the preference, the recipient is better off than they would have been if a bankruptcy had been filed instead of on the day that the money was deposited in the recipient's account. So as we look at a preference, let's define a little bit more clearly. We've got some slides. What is a preference? In chapter 7, for purposes of this illustration, we're going to guess the unsecured creditors will get 15% of their claim. When preferences are threatened, the reality of the situation is we're not sure how much is going to be there. But to make it easier for us to determine whether certain transfers are preferences, we are assuming an unsecured dividend of 15 cents on the dollar. 100 days before the filing of the bankruptcy, the creditors owed $110,000. Clearly, that's not a preference because there hasn't been a transfer. There's just debt on the books. 95 days before the bankruptcy is filed, the debtor pays that creditor $10,000, taking the amount that's owed from $110,000 down to $100,000. Was that payment of $10,000 a preference? No, it wasn't, because it was greater than 90 days before the bankruptcy was filed. The next payment made 85 days before filing the bankruptcy is $15,000, taking the outstanding debt from $100,000 down to $85,000. By itself, if the estimated liquidation payout's 15%, this creditor is still out 85% of his claim. It's not a preference. 10 days later, at 75 days before filing, the creditor gets paid another $20,000, taking its total remaining balance down to $65,000, meaning that it has received 35% of the amount it was owed 90 days before filing. That final payment of $20,000 is a preference, and the reality of the situation is the law firm seeking to recover preferences will seek to recover the $15,000 as well, because the reality is nobody really knows where we're going to shake it out, how much it's going to mean. So, having said that, what's the process in a preference? The process in a preference goes like this. Typically, that happens in large bankruptcies and in some small bankruptcies. There's a standard format. Usually the debtor or a liquidating trustee sends out demand letters asserting that the recipients, in our case, Dean Foods, milk sellers, and other creditors, owe money back to the bankruptcy estate. They generally settle the offer for less than the full amount that's owed, that they claim is owed. If that doesn't work, the debtor will file a lawsuit in the bankruptcy court seeking to get the money back and recover the preferential transfer. In this case, we believe, since the Dean Foods case is filed in Houston, that the lawsuits would be filed in Houston, not in Iowa, not in Pennsylvania, not in Ohio, but in Houston. So there could be a lawsuit. It would be filed in Houston, most generally. Throughout the process, the debtor and the party seeking to get the money can negotiate, try to make a deal. We're at that demand phase now where negotiations can take place. ASK LLP generally calls recipients to verify their demand letters to make sure they went to the right party and to push for settlement. So it's possible that you received calls from this law firm as well, seeking to get you to capitulate and pay them money. Must you pay the demand? No. And that's really what I'm saying. I don't believe you should just pay the demand. You need to evaluate it. First off, if you're like a lot of farm families I know, you haven't got a lot of money to send back to somebody. And in most instances, dairy farmers should not have to do it. You may have defenses, and there are a number of defenses we're going to discuss about the Dean Foods demand letter. We've seen two outlines of those, and since the goal was to persuade the producer to pay without a fight, the letter didn't go out of its way to encourage asserting the defenses. In fact, they tried to make it very difficult. What kind of defenses do we have? The first one that we saw addressed in the demand letter from the ASK LLP talked about subsequent new value. If a creditor received a preferential payment but then made another delivery that wasn't paid for, the subsequent unpaid delivery could shield the payment from a preferential demand. An example: milk was delivered the 1st through the 15th. An advance payment was received on the 25th. Milk was delivered after the 25th when the advance was received, and that milk that was delivered after that by itself would be subsequent new value. That's the farmer provided new value to the Dean Foods by sending them more milk. So to the extent that that milk hadn't been paid for, its subsequent new value would protect the first payment. The demand letter we saw did attempt to make reference to the subsequent new value, but it showed us absolutely nothing, so we could determine what analysis, if any, had been done regarding the new value. We don't know if it was accurate, but at least it appears to have been considered. Let's take an example on a variant of the earlier example. In this one, the supplier received a $15,000 payment, then delivered $15,000 more in new supplies, or milk in this instance. If that's the case, that delivery of the new milk or new supplies covers the payment of the $15,000 that would have been a preference. But there are other defenses as well. Let's discuss the one that's going to be the strongest defense for milk producers: the ordinary course of business defense. So long as the payment was normal, either for the industry or the supplier's relationship with Dean Foods, then the payment is not a preference. If a milk producer received milk checks like clockwork, then they win on this defense, hands down. Receipt of regular milk checks on time or electronic deposits are the ordinary course for the industry. They follow federal milk marketing orders, and they were also the ordinary course of business for the producer's relationship with Dean Foods. The demand letters we've seen, does acknowledge this as a defense, but it framed it deceptively. It doesn't acknowledge the ordinary course for the industry prong of the defense, and it demands an onerous documentation of the payments to assert the ordinary for the relationship prong of the ordinary course of business test. Quite frankly, it's misleading. Assuming as a producer that you sold milk, got your advance, continued delivering milk, got your settlements like clockwork, there should be no reason that these letters should have ever been sent. It indicates to me that any good faith analysis of what had gone on appears to have been skipped. You're probably going to be interested in figuring out how you can document an ordinary course of business defense. Send an email to deanfoods@ablsonline.com or call 319-363-1641. And we'll be happy to send it out to you so you can have your information together. The types of information that you're going to be putting together as a dairy producer should be relatively easy to put together. And it should be okay. People can do the same if they're not dairy producers. I assume that the milk haulers and others will probably have different things happening. Unfortunately, we understand that the hauling charges or trucking charges were deducted from the farmer's check, but not remitted to the haulers on time as they should have been. That's unfortunate, and their defenses to the preferences may not be nearly as easy to step up with and bring forward as you can bring the defenses up for the dairy farmers who presumably were paid like clockwork. Now, there's a third defense to preference. It's called contemporaneous exchange. This is generally cash on the barrelhead. I go into a store and I buy something and get something back at the same time. So payment on delivery type of arrangement is like cash on the barrelhead, and it's a good defense to contemporaneous exchange. In Iowa, there's a case law saying that payments even 7 days after delivery can be considered contemporaneous. However, since milk payments generally come 11 to 17 days after delivery, the contemporaneous exchange defense would not be much, wouldn't help covering payments for milk, because it'd only be helpful if they receive payments outside the ordinary course of business and it came a lot earlier than normal. We know that's not the case. So, must I pay that demand? The preference defenses. Another defense is the 20-day administrative priority. It's a little different form of a defense. In the 20-day administrative priority, any deliveries made within 20 days of filing the bankruptcy, which would take you back to October 23rd of 2020 or 2019, must be paid for at a higher rate, and it gets a preference or priority over deliveries that were made more than 20 days before the case was filed. While you can argue it may be like a defense, it's not quite. It just means that if they're going to get paid in full as an administrative expense priority, there's really no reason to take the money back as a preference. One more provision for the smaller preference defendants. If the preference amount is less than $25,000, the lawsuit or adversary proceeding is only supposed to be filed in the defendant's home court. So if you're from Northwest Iowa, it ought to be filed in federal court in Iowa if they're seeking less than $25,000. It doesn't mean that ASK LLP couldn't file the lawsuits elsewhere, but if they did, that case should be transferred to where the defendant is. In order to do that, she'll need to have a lawyer work forward on it. So now you've seen a bit of background in bankruptcy and preference actions. You've seen that there are many avenues to defeat alleged preference liability. The next step is on you. If you received a letter, do not ignore it. Start assembling the documentation, primarily delivery and payment records, but also any correspondence you had with Dean Foods or the other dairies within the Dean Foods group for the period of time of the preference. In addition to that, you may have contracts for sale or delivery of milk, which could provide yet another potential defense. If you're a producer, While you're gathering the information, also hope that the Farm Bureau demand is effective. I've been in contact with Farm Bureau and asked them to let me know whether ASK LLP backs down from chasing producers. We can't be sure that's going to happen. Since we can't be sure that's going to happen, it would be unwise and short-sighted to sit by idly, hoping that ASK LLP will see the light and withdraw the letters. If you prepare to respond to the demands, and the demands are not withdrawn, you'll be ready to retain an attorney and give them the information they will need to respond to the demand. For other suppliers, now is the time to retain counsel and begin preparing your defense and your letter back to the folks at ASK LLP. You need to be prepared so you can provide the information in a fashion that can get the job done. So we've gone through, we've covered what a bankruptcy is, what a preference is, what potential defenses to a preference can be, and how potentially the Dean Foods preference letters to producers at least should be withdrawn. We hope that that's the case. Anyway, for more information, and if you wish to send us information, email us at deanfoods@ablsonline or call us at 319-363-1641. Thank you for coming and attending our presentation. I'd be happy to answer any questions you may have. I'll answer questions from the chat room or chat thread and start taking any other questions from people who raise their hands to speak. If you're participating through a computer or smartphone app, there's a raise hand button you can tap or click. If you dial on the phone, you can press *9 to raise your hand. When we call in you may receive a prompt to unmute yourself. That's the microphone button for those on computers or smartphone apps, and *6 for anyone joining telephonically. And we'll also try to call on you verbally. Well, seeing no hands being raised and not hearing any questions, thank you again for attending. We appreciate it. We hope and pray that the Farm Bureau letter is honored and the demands are withdrawn. That will help for the dairy producers, but I doubt that it will do anything for the other creditors. Good luck. We'll be back online again next week, Monday at 1 p.m. Have a great day. Goodbye.